Did you review those records for any information that might be relevant to IV access?
Yes, I did.
In your record review, did you see any records that indicated that Ms. Pike's veins would be difficult to access?
Not based on what I read in the records.
Did you see any records concerning phlebotomy?
I did.
Did you draw any conclusions from those records?
The records that I saw from, I did draw conclusions.
Can you explain those?
Yes, based on what I saw, there were a number of documented phlebotomy visits, and with the exception of one of them, all of the phlebotomy procedures were successful on the first attempt, and on one of the attempts, it took 2 attempts to secure access to the phlebotomy.
And what, if anything, did that tell you about venous access?
That tells me that that's pretty standard to do 1 to 2 attempts, so that tells me that this is a standard, not difficult to access patient.
Did you notice in those phlebotomy records where the blood was drawn from?
Yes, there were 3 different areas: the hand, what's called the forearm, and what's called the anticube, which is the area of the bend of the elbow.
In any of those records, did the location of the blood draw lead you to draw any conclusions about venous access for Ms. Pike?
No.
Did those phlebotomy records indicate the size of the needle that was used to draw blood from Ms. Pike?
Yes.
Do you recall what size needle was used?
Yes, they were the standard 23 gauge phlebotomy needle, butterflies.
You just referred to that as a standard 23 gauge needle. Can you explain why?
That's a very frequently used for phlebotomy, especially in the hospital setting. But that is very frequently used for people. It's less painful.
Did you draw any conclusions from the fact that a 23 gauge needle was used to draw blood from Ms. Pike?
No, that's a standard needle.
Now, you stated at the beginning of our time together that just yesterday you had seen a patient with a clotting disorder of some kind. Is that correct?
Correct.
Have you ever started IVs in patients with platelet disorders?
Yes, both too many platelets and too little platelets, yes.
Let's talk about patients with too many platelets. Are you aware of Ms. Pike's platelet counts?
Counts, I'm not, no.
Are you aware that she alleges that she has a condition that results in elevated platelet counts?
Yes,
And you have started IVs in patients with elevated platelet counts, have you?
I have not with a particular quote-unquote diagnosis, but yes, I have.
If it comes to your attention as a nurse that a patient has an elevated platelet count, do you take that into consideration when placing an IV?
Not just, well, in placing the IV, likely I would, which I always prefer to go on a forearm because those are the most stable areas to place an IV. But it would more have to do with the aftercare and the infusion and what exactly our goal is in starting this IV.
So in terms of achieving the IV access, would you do anything differently for a patient with an elevated platelet count?
No.
Those are all my questions. Thank you, Nurse Campbell.
Thank you.
Good morning, Nurse Campbell. My name is Suzanne Bales. I represent Ms. Pike. I'd like to talk a little bit about your more recent experience. What is the most recent presentation that you've given?
It was last September, I believe, at the Association for Vascular Access in Orlando.
So that was in 2025.
Correct.
How many presentations did you give in 2025?
Probably one.
Okay. And how many presentations did you give in 2024?
I'm not sure if I did. I'm sorry, I don't have my CV in front of me.
You're not sure if you did give presentations in 2024?
I don't remember off the top of my head. I can pull up my CV. I apologize, I didn't.
Okay, could you pull it up? I'm just confused because the CV shows your last presentation was in 2015, but when
Oh.
you discussed your CV, or when you were discussing how many presentations you did, you said you had done several recently. So I'm trying to understand what
Yes.
CVs you did recently.
Oh, hold on one second. I have it, let's see. It says my last presentation was 2015?
Yes, ma'am.
Is that, so what I have on my presentations, the last one on the list I have is update your infusion therapy toolbox. Is that what you're referring to?
Yes.
Yes. And above that, there's mentoring graduate nurse, that's 2013. I have urban legend of the 10 ml syringes presented to the Infusion Nurses Society in 2019. And then 2021, I have myths associated with vascular access and infusion therapy
Okay,
in August of 2021.
I don't see that on your CV.
No, that's weird. Okay. I don't know. That's what I have that I sent to the agency. I don't know.
So you have one in 2021 that is not on the CV that you provided
Yes.
to this court?
And last summer as well, yes.
What,
Do you want me to take
I can-
this and see if she can pull up her current CV?
no, Your Honor.
I know sometimes you storm and get more than one CV and all
Right.
that. I'm wondering if she sent in the wrong one.
Which would mean that the incorrect one was disclosed to us.
Okay.
You want me to see it? Whatever you want to do.
I believe she testified that she reviewed it and it was accurate, the CV that was presented to
You
the
want me to leave it
court.
on? I just didn't know if you wanted access.
I just would like to know how many omissions there are from the CV, is what I'm getting at. How many presentations did you do in 2022, ma'am?
2022?
Yes,
None.
okay. And 2023?
None.
And 2024?
None.
Okay, you're sure about that?
Yes.
Okay. So when you testified earlier that you've done several presentations recently, that would just be one in 2025?
Objection, misstates
Just
the
when I
testimony.
said,
I'm sorry, we had an objection when the lawyers start talking over you, that means someone's probably making an objection and just pause a second. Yeah.
The objection was the misstatement of testimony. She testified that she,
It's cross-examination, I'll let her continue to ask.
Okay, so one presentation in 2025, is that correct?
That's correct.
And then we jumped to 2023.
None in 2023, I believe.
Okay. I believe you just testified that you did have some in 2023, or at least one in 2023.
I said 2021, 2019, 2013, but I don't believe I said 2023.
Okay, well, the record will reflect. Okay, let's talk about professional achievements. The last professional achievement I see on your CV is from 2020, but I believe you testified differently than that.
Is there a question there, Your Honor?
Okay, would you, ma'am, you testified that the CV that you reviewed was accurate. Do you agree that that CV is accurate?
You can show me to the review and give it some time to review.
Do you have a,
Ma'am, do you have your CV in front of you? Can you get
I
access?
have one in front of me, but it sounds like it's not the one that the agency sent over, so
okay,
We're going to show you the one that was sent in that was disclosed to the party.
right.
And council's going to ask you whether or not this is your most recent CV. She's going to ask you whether it's accurate.
Understood.
okay.
Do we need to scroll down?
Just professional achievements, is that accurate? Just yes or no?
I'm just looking at it. Expert. From where it goes to American Nurses Association, that so far is accurate.
Okay, scroll down.
Ma'am, she's also asking you if there are omissions.
From there, no, the only omissions would be, it looks like that my presentations are not updated, but see, this here does have the 2020, you said my last presentation was 2015. This does have the 2020, but this is not, I do have two after the 2020 that appear not to be in this version.
Okay, so this is not actually accurate.
The most updated, correct?
Okay, ma'am, one thing I bet is accurate on this CV is that you state you're especially passionate about educating folks on best practices for gaining venous access. Is that a fair statement?
Yes.
Okay. And you're familiar with, I believe you mentioned this earlier, you're familiar with the infusion therapy standards of practice. Is that correct?
That's correct.
And in fact, you're on the peer review panel for that.
Correct.
And you reviewed these standards in preparing your statement, your report.
Correct. Correct.
And it's an evidence-based document. Is that correct?
That's correct.
Okay. And the standards of practice state that vascular access requires clinical experts. Is that correct?
Correct.
And the reason for that is that gaining peripheral access is invasive. Is that correct?
Yes,
and it is a high-risk endeavor, is that correct?
that's correct.
Okay. So gaining venous access is a high-risk endeavor, that's correct?
Yes,
Okay. So a standard that says education alone is insufficient, is that correct?
yes,
A practice for gaining venous access that just relied on education is insufficient, is that correct?
if by education we mean just learn, not hands-on, then yes.
Okay. So you guessed my next point. The standards of practice require observed clinical competency. Is that correct?
That is correct.
And it requires ongoing training. Is that correct?
Yes,
And the standards of practice state that the competency of a person who is going to gain venous access should be routinely assessed.
I'm going to object to this line of questioning insofar as it's a backdoor to try to get to the qualifications of the physician.
Your Honor, we had testimony about the training, and Commissioner Thomas testified that she confirmed their licensure and that they had 20 years of experience. This is about the people who will gain IV access, and the fact that she's an expert in that area, that this is like her core expertise, and she recommends that a 20.
Rule in your favor, please stop talking.
Okay, thank you, Your Honor.
I'm overruled.
So the competency of a person who's going to insert an IV should be routinely assessed. Is that correct?
that's correct.
For example, if a clinician makes 2 attempts at gaining venous access.
Objection, this is getting at the physician again, Your Honor.
Your Honor, I think he doth protest too much. This is clearly about the IV access team. I'm asking her, she,
Don't ask about the IV access.
okay, I'll be sure to preface.
I thought you used the word physician.
I think I said clinician.
Oh, maybe I misheard.
Okay. But I'll preface, I'll wrap it up, Your Honor.
Clinician.
Okay.
I didn't hear physician.
I understand. A person who's, an IV person who is attempting to gain IV access, after 2 attempts, the standards of practice say they should ask someone else to do it. Is that correct?
That's correct.
And the reason for that is there is a risk of complications after 2 attempts. Is that correct?
Partially correct, yes.
Okay, well, that's what the standard of practice says. We could pull it up if we need to.
That's a standard practice.
Yes, Your Honor, that's the infusion therapy standards of practice document that she relied on in preparing her report.
That's a standard practice for well-care people.
Well, it's the standard,
Standard practice for executing people.
no, it's not. It's the standard of practice for gaining venous access, which is what her expertise is in.
Okay. But there's a distinction, isn't there? Is there a standard of care for peripheral IV access if the intent is to cause the death of someone?
Your Honor, there is. If there are no standards, or if there are unreliable standards for the IV team to gain IV access, that increases Ms. Pike's risk of added.
No, I didn't, I said, is there like an organization that has standards for the quality and level of training for people to gain peripheral access, peripheral IV access situation where the person is going to be dead.
Your Honor, the complication of extravasation would be applicable,
So
and
there's some that will, but
Yeah.
some might not. Okay. But you're talking about the standards that you would use in a hospital setting or a clinic, when the patient, the goal is to preserve the health of the patient.
I believe she testified, based on her experience, she made a recommendation for how to administer the lethal injection chemicals. That's what I'm getting at. She relied on this document to give this recommendation that,
As you go forward, I was just seeking clarification about the standards.
okay. The standard of practice emphasizes that peripheral IV access should be gained by people who have clinical knowledge and skills. Is that correct?
Correct.
Okay. The standards of practice state that a patient's self-report is the most valid and reliable indicator of pain. Is that correct?
Could you repeat the last word, please?
The standard of practice states that a patient's self-report is the most valid and reliable indicator of pain. Is that correct?
Objection, I'm going to ask that she be given a chance to look at these standards of care to answer these questions about what they contain specifically.
Happy to do that, Your Honor.
I would assume you have it in front of her.
Well, we can, do you have your copy of the, ma'am, do you have your copy with you of the standards of practice? Or we could.
I can pull it up.
Okay,
I can pull it up.
okay. We'll use that. I think that'll be quicker. I'm almost done with the standards of practice, by the way.
Okay, I have my standards document, and could you let me know what page we're on or where we are?
Ma'am, they posted a copy on the link here. Is that what you have, or do you have a different copy in front of you?
I have the one that's on the screen right now, that's what I have, that's the latest version, the 2024 standards.
She's going to call your attention to specific pages, I believe.
Right, okay.
Okay. Can you go to PDF page 107? Ma'am, we're going to PDF page 107 out of 291. That might be quicker.
Okay.
How does that correspond to these page numbers?
I can call that out also. Okay, that is page S45.
Thank you.
S45?
Yes, I'm calling that I guess the paper document pages out for council, but we can also look at the PDF number.
Okay, sorry, I'm just pulling it, I'm trying to get to that page, S45.
Pardon? Is that one I know they're different, it's confusing.
I'm sorry, let's see. S60.
All right.
That's 4, 5.
Okay, I believe we're here.
Okay, hang on. I'm sorry, could you go to S107, please?
Thank you.
I'm sorry, we said S45, is that correct?
I apologize, I got a little sideways working with the different page numbers.
Okay,
I'm at S107.
okay.
S-107 on the right side, paragraph C,
Okay,
the standard of practice says that you should use pain relieving measures to reduce insertion-related pain. Is that correct?
I'm just gonna pull it up. All right, let me see. Yes, it does say that.
Okay. If we could go to S-101. Paragraph D, subpart 5, so you'll need to, thank you. Go scroll down to, we can see paragraph 5.
Okay,
The standard of practice provides that a patient's self-report is the most valid and reliable indicator of pain. Is that correct?
correct.
Ma'am, I'm going to switch to your report now.
Okay. Okay.
In your report, you state that you reviewed Ms. Pike's medical records. Is that correct?
Yes, regarding the phlebotomy access.
Okay, and how many pages of records were you provided?
Pages. I don't know how many, the number of pages. I looked at the phlebotomy records.
And how many pages of phlebotomy records did you review?
I don't know the number, how many there were, the number of pages.
Do you know how far back, or the period of time for the records you reviewed?
I don't, off my head, no.
Okay. So, but your report says there's no documentation that Ms. Pike had difficult access. That's in your report.
From what I read, there was no indication of difficult access.
Okay. I'd like to talk about the 23 gauge needle.
Yes,
Is it your testimony that a 23 gauge needle is commonly used in mine run blood draw? Or you said it's very commonly available. Is that your testimony?
yes, it's commonly used in phlebotomy daily.
But that would be in a hospital setting, is that correct?
Not just hospital, clinic, home care.
Okay, but I believe you said it's most commonly in a hospital setting.
That I said that?
You mentioned it's very common in a hospital setting.
I don't know that I said in a hospital setting, but it's a very commonly used needle for phlebotomy.
And is it your testimony that it's used when it's not necessary?
Objection vague.
I'll let you rephrase the question.
Okay,
The question that
okay. You said that the 23 gauge needle is used commonly. And
Yes,
did you testify that it's used to make access more comfortable?
it can be used to make access more comfortable. I can explain further.
Okay, is it used every single time for a patient when it's not necessary? Have you encountered that situation?
Objection, foundation as to what's necessary.
Talk to her about necessary.
Okay, ma'am, when is it necessary to use a small gauge needle?
So that particular needle, the butterfly needle, is actually very commonly requested by patients for their phlebotomy.
And that's your testimony under oath? That's your testimony under oath, is that patients commonly request that?
Request a butterfly? Absolutely.
That's your testimony under oath?
Objection, she's answered this question twice now.
Yeah.
Is it the practice that whatever the patient asks for, the phlebotomist does?
Very frequently, yes.
The-
And the nurse does as well.
Okay, they let the patient dictate their,
If it's within reason, absolutely.
okay. So we know that a 23 gauge needle is going to be slower, is that correct?
Objection, foundation.
I'm sorry. I'm going over it.
Ma'am, a 23 gauge needle, the fluid moves through a 23 gauge needle at a slower rate, is that correct?
At a slower rate than a 21, but a faster rate than a 23, yes.
Okay, a 23
I
gauge.
mean, that slower rate than a 20, would be 21, 23, and 20, yes, it moves fast, slower than a 21 gauge, sorry.
Okay. So it moves slower than other commonly available needle sizes.
For phlebotomy purposes, yes, and for infusion purposes, yes.
A 22 gauge is commonly available.
A 22 gauge is an IV catheter.
Okay,
That's not a phlebotomy needle.
fair enough. How about a 20 gauge?
A 20 gauge is also an IV catheter. Those aren't used for phlebotomy.
Okay, a 21 gauge?
A 21 gauge is a phlebotomy needle. That's a butterfly. I'm not an expert on these. There are two types of needles that are used for phlebotomy. There are the butterflies, which are very commonly requested, and this, not just at my facility, I just know this anecdotally from speaking with other practitioners, but that there are also what they call the straight needles that some phlebotomists use in phlebotomy clinics that I don't, off the top of my head, know exactly what the gauges are. They're likely the same because they're odd numbers versus the even numbers for IV catheters.
You would agree with me that the smaller the needle, the slower the blood draw will happen.
Objection to the relevance of further questions about phlebotomy. This is outside her area of IV access expertise. The reason phlebotomy was an issue is the medical records, not what is the standard of care, what happens in phlebotomy generally.
Your Honor, she's drawing an inference that there's absolutely no reason to use a 23 gauge needle as reflected in Ms. Pike's records, and I'm trying to understand how she got to that conclusion.
I give some leeway, but I don't, you're probably getting close to ending this.
Okay.
I'm going to give you some leeway.
Okay, I'll ask my last question then. Would you agree, related to that topic, would you agree that the smaller the needle, the slower the fluid travels through it?
Yes.
Thank you.
I don't want to be dead horse, but we have about 4 experts that say that already.
We have. I'm trying to understand the basis for her opinion, Your Honor. On page 6, you've got your conclusion,
Okay,
and your conclusion is that placing a peripheral venous catheter utilizing a 22 gauge or larger would allow the infusion to be given in the most humane way possible.
yes,
And that's based on your years of experience and based on using the standards of practice that we discussed. Is that correct?
yes, a 22 gauge or larger, because I was asked originally to discuss the 23 gauge
Okay,
butterfly.
just answer the
versus-
question, ma'am. You're recommending a 22 gauge or larger, is that correct?
Yes,
And your opinion, your declaration is that that would allow a humane infusion, is that correct?
correct,
Ma'am, your declaration states that you reviewed the protocol, is that correct?
yes,
And the protocol has a section on the IV team. Is that?
yes,
Does that section on the IV team have any requirement for, does it have any requirements for education?
I'd ask the witness be shown the protocol and referred to if she's going to be asked questions
yeah,
about it.
because
Can you put up the protocol, sir?
Your Honor, we need just a minute. We're getting it up on the screen, ma'am. Okay. That number 1, did you, on the top section, did you review that?
yes,
And do you see the sentence that says all team members are currently certified, licensed, and/or qualified?
yes,
Okay. So we have no way of knowing if that includes education, do we?
well, if they're certified and licensed, to me that would say there was education.
Okay, fair enough. We don't know what their clinical
Correct.
experience is. Would you agree we don't know if they've demonstrated competency?
Just by that paragraph, I do not know.
We do not know if they've practiced IV insertion, do we?
Well, it says they're currently certified, licensed, and are qualified to place IV lines.
So, but that doesn't mean that they have been, we don't know what they're using to determine qualified, do we?
specifically by this paragraph, no.
In your recommendation for how to administer the lethal injection chemicals, you recommend a 22 gauge, is that correct?
I believe I recommend 22 gauge or larger, and to compare, what I was comparing the 23 gauge steel needle.
Okay.
But yes, a 22 or larger, yes.
Would there be any reason, or how, would there be a reason for there to be a 24 gauge in the execution chamber? That-
Objection, this is outside the scope of her expertise. She's not a correctional expert.
Well, there was testimony that there is a 24 gauge needle in the execution chamber, and presumably there's possibility of intention to use it. So I'd like to elicit testimony from her.
I'll let you ask the question.
Do you recommend using a 24 gauge?
So I always have everything available, all different sizes available to me based on a patient. A 24 gauge is a very small catheter, and it's typically used in children and babies. I don't, off the top of my head, know the infusion rate of a 24, but it would be fairly similar to the 23 gauge butterfly as far as the infusion rate. It would be safer and have a less of a chance of extravasating or puncturing through the vein, because it's not that we're not leaving a steel needle in sight, but it's a very tiny catheter.
Okay, how much pressure would it take to use that 24 gauge?
I'm sorry?
How much pressure would have to be applied to use that extremely small 24 gauge needle?
Objection, foundation as to what would be delivered through it, how much fluid.
Well, I was going to, before you objected, I was going to say the question doesn't make any sense.
Okay,
Can you
thank you, Your
rephrase the
Honor. That's
question?
helpful information. In the execution chamber, there is a 24 gauge needle offered as one of the options. And you just testified that it would go slow, but might be, what was your testimony about the 24 gauge?
It's a very small needle. It's typically used for pediatrics or neonates. I would have to look up what the infusion rate is, but it would be safer than the 23 gauge steel needle as far as being more stable and not causing issues with the vessel, but it would not be as, the infusion would not be as quick as with the 22 or larger.
Are you aware of how much pressure is applied to push the fluid through a 24 gauge?
We have the same problem.
Yep.
The question doesn't make sense because it's pressure to get a certain amount of fluid. If you want to get just a tiny bit of fluid very slowly, then you probably can have less pressure. If you want to get a certain amount of fluid in a certain amount of time, you're going to have greater pressure. So when you ask a question about how much pressure, that doesn't really get to what you really want to ask.
Okay.
And it's vague because it by itself doesn't make any sense. Am I making sense?
Okay, I understand, Your Honor.
Okay.
Ma'am, in your conclusion, you testify that using 22 gauge or larger would allow the infusion to be given in the most humane way possible. You've reviewed the protocol, is that correct?
Yes.
We're going to pull up the page in the protocol that talks about the amount or the quantity or the volume of the injection.
this point, I will object to the relevance of this line of questions. She has not testified that she believes a 24 gauge needle is appropriate. If she had, perhaps this might be relevant to determine what the pressure rate would be, but this is not an issue that is live.
It's just going to take a lot longer.
Your Honor, I'm trying to understand, she's made a very serious recommendation, and I'd like to get to the bottom of that. And it's very important to Ms. Pike's issue. Okay, that's what the infusion, what you're calling an infusion. That's what's going to be injected.
Right.
And do you recommend a 24 gauge needle for that?
Would I recommend a 24 gauge needle for that?
Yes, in your experience.
I don't know that I would use a 24 for that. I would use a 22 or larger.
Why is that?
Because of the amount of time it would take.
It would take a longer period of time?
Yes, I believe, I had a chart, I believe, of different, from my 22s up to 18s. So a 23 would be fairly similar to the 24. I don't have the 24, I did not include the 24 because, again, it's more of it's a smaller catheter, it's a smaller needle. So I was looking more to compare the original proposal of the 23 gauge phlebotomy needle with what would be standard catheters.
Okay, so to be clear, you do not recommend a 24 gauge for this process?
All things being equal, I would not, but I'm not with the patient, but to do it in the quickest way possible, I would not necessarily use a 24.
Okay, thank you. I have one more question. What is extravasation?
Extravasation is the inadvertent infusion of a vesicant medication into the tissue versus in the vessel.
Can we go to page S257? And I apologize, I don't have the PDF number for that. Ma'am, we're pulling up the extravasation staging. There's a
Yes.
chart about that.
I'll have to pull up the standards again, I'm sorry. I
Okay,
closed
we're
them to-
getting it up. We're just taking a moment. In fact, you could scroll down so the top half is visible. And are you able to enlarge it?
Oh, oops. Okay,
Okay, so in stage 4, the last factor that you look at, can you read that?
You want to read it?
yes, I can see it.
Okay, so that's for the record, one of the factors for stage 4 extravasation staging is skin breakdown, including blistering or necrosis. Is that correct?
Correct,
Are you familiar?
correct.
Ma'am, are you familiar with pentobarbital?
I have not used it, I know that it's a vesicant.
You know that it's, pardon, you know that it's a what?
It's a vesicant which can cause extravasation.
Okay, thank you. And the larger the quantity, the larger the possible blistering or necrosis. Is that correct?
That would be correct. The extravasations happen in stages. We don't normally jump from a no extravasation to a 4, if that makes sense.
Okay, but you do agree that pentobarbital can cause burning? Or-
It could, if it leached into the tissue, it could.
And a needle that's too big could tear the vein, is that correct?
I'm sorry?
If the IV team in Ms. Pike's protocol uses a needle that is too big, it could tear the vein, is that correct?
Could tear the vein.
Or damage it?
It could potentially damage it. It depends on the size and the size of the vessel.
Okay, so but that is something you agree is possible if a needle that's too big is used?
If the catheter that is too big is used, it could take up too much space in the vessel, thus not allowing for enough hemodilution that could cause some issues with the vessel, yes.
Okay, and if some issues with the vessel happen, the pentobarbital could leak out of the vein, is that correct?
It's possible, yes.
May I have just a moment, Your Honor? Your Honor, no further questions.
No redirect, Your Honor.
Any more witnesses?
No, Your Honor, that concludes the state's proof.
Any rebuttal?
Your Honor, may we have just a moment to discuss?
Okay, why don't I take a short recess? And then we can discuss that, and then if you decide you're not gonna have a rebuttal, why don't you get ready for our presentations?
Okay, thank you, Your
If
Honor.
if you did decide, then we'll come back. 10 minutes enough?
I was gonna try. I was gonna try to tangle it. So I was just go around. I'm sorry.
Yeah.
That won't be a problem.
Yeah, I'll let them go over.
So that's gonna be. And then he's gonna review all that. He'll review the arguments that are being made, he'll review the testimony. He will prepare a report for the support court based on what's been said. Buddhist advisors are been advised. There really is no issue. The state's already said removal no earlier than 24 hours, so that's already. So the issue is there are the 3 things, whatever, and then alternative. He's gonna go, but he might, one of the tricky things here, and this is, I don't know this, but here's my hunch. They throw out this is kind of crazy bullshit.
Yeah, I saw
The
that.
statutory that says it is a retribution. Statutory in the law. Some inmates have taken witness to retributions as a kind of law. You don't want that. I don't want it either.
Yeah.
Yeah, I don't know what's going on. It's really weird.
Opposing someone's statement. And then they're also going to incredibly sensitive aspect of prosecution, which is central line. Central line.
Yeah, and it's weird though, because how,
The last time they did this with the central line, it got fucked up.
Yeah.
And they know that. I think this is also
Meeting no problem doing the execution
Yeah.
today, would that mean that change anything?
Well, I don't think the
Okay,
quarterly
yeah, for sure.
whatever happens.
Yeah, I'll let you check it out.
The same dude. Oh, I don't,
Okay, I thought I saw that.
that may be,
Maybe I
I'm not
misread,
denying it,
but-
but we don't know.
Okay.
I mean, the thing is that doctors do not
Yeah.
kill patients.
Yeah.
Yeah.
So getting a doctor,
Yeah.
yeah, getting a doctor to agree to put somebody down
Yeah.
is hard.
Yeah.
And the state knows that. And this guy who did it in a way that couldn't find a central line. No, he's like, hasn't done some of this shit in years. So he's probably some schlub that was like, okay, yeah, I'll do it.
Yeah.
He's probably evil or bad.
Yeah.
opportunities to briefly articulate where they think we are on each individual question that we have. Anything that you lawyers believe that you can agree on, I would appreciate knowing about that. And then next week, you'll be submitting your findings of fact, proposed findings of fact and conclusions of law. And then we will be anticipating receiving the transcript. Hopefully, I believe we're going to get the transcript by middle of next week. Does that mean you will not have it to help you with your findings of fact and conclusions of law? Okay. So anyway, that being said, let's have our presentations. However you want to present it, we'll start with the movie.
Thank you, Your Honor, and I was just prepared to go through all 4 of them one by one and talk about what we think has been shown. Okay. And the first issue is, given the diagnosis of thrombocytosis, attempts to achieve peripheral IV access under the current protocol are sure or very likely to cause serious illness and needless suffering. All of the experts in this case agree that Christa Pike suffers from essential thrombocytosis. They agree that thrombocytosis is a condition that produces excess platelets in the blood and that excess platelets can lead to clotting. This increases her chances of suffering during an execution under the current protocol. Dr. Mansour testified that any risk is not implicated until the platelets reach into the 1 millions. Dr. Van Norman explained that the longer a person has thrombocytosis, the greater the risk of microvascular complications and clotting. Repeated blood draws during the management of thrombocytosis can make the veins more fragile and more prone to rupture. Dr. Van Norman also testified that thrombocytosis increases the risk of clot in an IV line. Dr. Zivit, who is board certified in critical care and anesthesiology and who has treated patients with thrombocytosis and has experience managing the care of critically ill patients with coagulation issues, testified that Christa is at increased risk of clotting and, paradoxically, excess bleeding during the execution because excess platelets can consume a critical blood clotting protein. Dr. Zivit explained that based on his review of inmate autopsies, that lethal injection by pentobarbital causes pulmonary edema, which is blood and other fluids in the lungs. He confirmed that the autopsies of 2 Tennessee inmates executed under the current protocol both had pulmonary edema. He explained that it's an extremely painful condition characterized by a sense of drowning and burning, and also explained that pulmonary edema, which can only happen if the patient is breathing and blood is circulating, happens while the patient is alive, and it's unclear whether the patient is unconscious, insensate, or conscious and sensate. And we just don't know the answer to that question. Dr. Zivit explained that Ms. Pike's thrombocytosis increases the risk of clotting in the IV sites and along the IV lines. Dr. Mansour testified that he would not rule out this risk, but that her elevated platelet levels were not concerning to him. However, I think it's important to remember that Dr. Mansour had reviewed a limited number of the medical records provided by the state concerning Christa's thrombocytosis and platelet counts, that there were a number that either he did not review because he didn't receive them or he overlooked them in his review process. Dr. Mansour testified that 2% of the population have platelet levels exceeding 450 up to approximately 525. However, the records that were provided to him show that Ms. Pike's levels have exceeded that figure, and he did testify that that wouldn't change his opinion, but I think that that's important, that those excess numbers are there. As to the second issue that has been referred to this court, number two, that given Ms. Pike's, oh, I'm sorry.
Just a second. I'm not telling you, are you going to come back to the first issue and tell me what the conclusion of law should be from these facts? Or are you just giving me your view of the facts?
I was just planning on giving the view of the facts at this
You're not
time.
gonna get into
I could, yeah, that's, I think,
No, if you.
yeah, I think we got the instructions, and I'm not sure
Well,
was,
the court has to send in findings of
Right.
fact and conclusions of law on each, just on the narrow
Right.
question. So, I'm not telling you want to limit it to facts, that's fine.
and I think that there are some, I won't say that my entire presentation is limited to facts,
Okay, just,
but,
I'm going to keep my mouth shut. You go where you want to go. This is to benefit council as much as it is to benefit me.
okay, thank you, Your Honor.
And
But I do believe, just the conclusion of law is that that increased likelihood of serious illness and needless suffering does increase the possibility that, given the defendant's or the inmate's presentation with thrombocytosis, there is a marked increase in the possibility that insertion of IVs and injection of pentobarbital will be more likely to either be difficult to achieve because of the compromised veins here, or more likely to result in a blowout, as some of the experts testified to, and that does increase the likelihood that an Eighth Amendment violation of cruel and unusual punishment will happen during the process of a lethal injection under the current protocol, given her diagnosis of thrombocytosis and the long history of blood draws she's had. And I know that gets more into the small and compromised veins, but the thrombocytosis itself will affect how the pentobarbital achieves or should achieve her execution. All right, the second issue is, given Ms. Pike's cited history of sexual assault and asserted diagnosis of post-traumatic stress disorder, PTSD, whether the movement of Ms. Pike to Riverbend Maximum Security Prison before the execution, where she would be observed by male prison officials for 2 weeks prior to the execution, would make it sure or very likely that the challenged protocol will cause Ms. Pike serious illness and needless suffering. Now, obviously, at the beginning of this hearing, we kind of established that there were some misunderstandings in how the issue may have been presented or understood, but that Ms. Pike will not spend 2 weeks at Riverbend. Under the protocol, she will be under close observation at DJRC, and according to the state, she will not be transferred to Riverbend Maximum Security Prison any more than 24 hours before the scheduled execution. So that, the factual premise is a little different than in the question presented to Your Honor. But both parties agree that that is the case.
Yes, I have to answer the question, but I guess what I'll probably do is answer their question and then answer a retracted similar question. And I guess that question should ask whether the observation for 2 weeks prior to the execution and movement to Riverbend Maximum Security Institution 24 hours before.
And it would be my intention, and we haven't conferred on all of this, but that we would inform the court, and probably both sides will do the same, that it's our understanding and our agreement, like you just asked, what things do we agree on? We can agree that the protocol sets out one process, but the state
has made agreements that I think are better for our client, and therefore, we're certainly not going to object to those changes. And I believe we've come to an agreement that she would be transferred not more than 24 hours, and that is when she would be at River
We'll
Bend.
address that question
Yes.
for them, but assuming that they need the answer to that question, I think that's what we're doing. That's how.
Yeah. Yes. I think the testimony of Dr. Bethany Brand, whose testimony was unrebutted about Christa Pike's psychological diagnoses and history of sexual trauma, is the most important on this issue. Dr. Brand, a clinical psychologist and a specialist on the impact of trauma, testified concerning Christa Pike's history of sexual assault that began when she was a preschooler and lasted throughout her childhood. Dr. Brand testified that Christa's sexual abuse began when she was just a preschooler and unfortunately continued throughout her childhood. She was raped again after the childhood incidents, raped again at age 11, and raped once again at age 17. In addition, some of her mother's boyfriends at least one committed sexual assault on her by touching her in a sexual way, and she was exposed inappropriately to a vast amount of sexual material. And that last rape at age 17 occurred almost exactly 1 year before the crime in this case. Ms. Pike was also physically abused in childhood, which, along with the sexual abuse, leads to that diagnosis of post-traumatic stress disorder. And Dr. Brand graphically chronicled how PTSD is likely to affect Ms. Pike at the time of her execution under Tennessee's current lethal injection protocol. And I begin with the close observation that in our understanding of the facts will happen at the Deborah K. Johnson Rehabilitation Center. And according to Dr. Pike, this will be triggering to have her observed in all of her activities every 10-15 minutes. It will be triggered, that close observation will be triggering to this survivor of serial rape because of the loss of bodily autonomy in the last few days. Now, the warden testified here that the goal was to staff all observers with only female staff. The state doesn't guarantee this, but they do say that they will strive to have only female staff observing. However, according to Dr. Brand, while men observing her would be much worse, women observing her in all of these close and personal and intimate activities is still going to be triggering for someone with this history of sexual assault. But if they are able to achieve only women observing her, I think that Dr. Brand admitted that the impact of that triggering would be lessened during the observation period. But regardless, she will be moved. Christa Pike has spent the last 30 years in one unit of one prison, except for very short trips out either for medical reasons or for a court hearing. But it's important, I think, to understand that her world is that very small one-unit place in a women's prison. She will be transferred in the last 24 hours of her life to a men's prison that she's never been to before, into a setting that's completely different and with guards and observers that are unknown to her. And that's certainly going to, and that's going to, would happen regardless, but given her history, that's going to be traumatic. The part of the process that cannot be ameliorated is the most traumatizing for her. The lethal injection protocol requires that Christa be placed on a gurney and strapped down before the IV team works to achieve venous access, or if they're unable to possibly set a central line because of her small and compromised veins. This process may last longer, than it does for other inmates. Dr. Brand testified that it is very likely to cause Christa Pike to relive her past sexual trauma of being raped, experiencing those rapes all over again as the state inserts lines into her to bring about her death. Because of this traumatic injury, because of her traumatic history as a serial victim of sexual abuse, Christa will involuntarily experience this superadded terror and psychological pain as the state executes her. Your Honor, that superadded pain and that terror and torture violates the Eighth Amendment. And it's what Christa Pike presents with against her own will. It's not like she manufactured these events, and it's not like she consented to them. These things happened to her and will cause her to be tortured at the time of her execution, however long it takes to get a line established and to get the drugs flowing while she's strapped to this gurney, surrounded by staff and unable to move. The third issue. Given Ms. Pike's allegedly small and compromised veins, whether achieving peripheral access pursuant to the current lethal injection protocol would make it sure or very likely that the challenged protocol will cause Ms. Pike serious illness and needless suffering. Dr. Van Norman is an anesthesiologist with over 30 years of clinical experience. She has placed thousands of peripheral IVs and thousands of central lines. She reviewed Ms. Pike's medical records and found multiple risk factors for difficult peripheral IV access, including her obesity, her scarred veins from repeated blood draws, her thrombocytosis, and her apparent small veins indicated by the use of a 23-gauge needle for blood draws. She also noted that most of the blood draws are from Ms. Pike's hand, which is a painful place to draw blood, and therefore the hand is only used typically when larger veins are unavailable. And we have, as indicated with the last witness, no information on the education and experience of the execution personnel. The witnesses that, I think one of the disconnects in some of these proceedings is that all of our medical experts practice in clinical settings, where, as you said, and in your questioning with the nurse, the goals are completely different, and the practices and the availability of expertise is probably very different. The facts that some of the experts, such as Dr. Mansour or the nurse at the end, talk about don't present problems are because they're in a clinical setting where they do this work all the time. And we have no knowledge, although what we have are the qualifications listed in the protocol that do not include people like Ms. Campbell, who are experienced vascular nurses that do this work all the time. Therefore, the fact of Christa Pike's small and compromised veins is a little different in the execution chamber. And that will cause the venous access to be more difficult, potentially prolonging the time needed to achieve that, and prolonging the time which she may be in the terror of her sexual abuse. Dr. Van Norman also explained that if too large a needle is used, it can cause the vein to tear. If too small a needle is used, there is a significant risk the vein will rupture because the fluid will exit the needle at an exponentially higher rate. This can lead to extravasation, which has been testified to by many of our witnesses, and the extravasation of pentobarbital will not only reduce its intended impact, but also create an extremely painful burning sensation. Dr. Van Norman compared it to Drano. It's that caustic. and it can cause significant burns. This would not only prolong her death because the drugs aren't getting where they need to be, it'll also make it more painful because the drugs will be burning the tissue around her veins. So it's any unsuccessful blowout or any of those complications have a very strong risk of making this a much more torturous process. And because Christa Pike presents with veins that have been drawn on many times and that are difficult to access, once again, is not something that she can control. It's something that she presents with, and that the state may or may not be, because we don't really know the qualifications, be able to reduce her pain and suffering. But there's certainly an increased risk of pain and suffering. Now, Dr. Mansour testified that he'd be less worried about Ms. Pike's thrombocytosis if the IVs were set in her elbow veins. But that kind of begs the question of why are they doing draws in her hands, which is more painful, if the elbows work. Now, I heard Nurse Campbell say that one of the times, I think it was one, I'm not sure if I get it right, but that most were in her hand. That's what the records indicate. And finally, the fourth topic of factual inquiry for this court is whether Ms. Pike's proposed alternative methods of execution would significantly reduce a substantial risk of severe pain. Ms. Pike has advanced 2 alternative methods for carrying out her execution besides the present lethal injection protocol as written that the state of Tennessee has adopted. These would be for the state to recognize the difficulty the execution team will have in placing 2 patent peripheral IV lines and instead administer pentobarbital directly through a central line that would be placed by a physician competent to perform the task at the time of her execution. This alternative, and I know the state quibbles about whether it's an alternative method, but I do believe the United States Supreme Court, the spirit of what they've been looking for in proposing alternatives is for the inmate to identify an issue that may cause an unconstitutional execution and identify what its possible solution would be. So even though this isn't necessarily an alternative method in that it's still lethal injection, it's still following the spirit of the United States Supreme Court that has said capital punishment is constitutional, therefore there must be a constitutional way of carrying it out. The alternative of starting with a central line is an alternative that makes the execution less torturous and less unconstitutional, needless pain and suffering that she would undergo. And it's not, if time is part of the problem while she's strapped down and being executed, which I believe Dr. Brand's testimony establishes that time is a problem, and I think most of us would understand that any time someone's laying there has got to be an awful amount of time. Given the fact that she has difficult veins, given the fact that this may be a protracted period of time, the placing of a central line is an alternative that would lessen that time and is available and easily implemented. Almost all of the doctors who testified to this court that had experience doing central lines would be competent to do that. Now, some of them may not be willing to, but there are doctors, as evidenced by the fact that a doctor is in the protocol, there are doctors willing to participate in executions. A doctor who's competent in placing a central line is the alternative Ms. Pike has identified. And that's readily available and easily implemented and would make this a much faster, and I don't like using the word humane, but it would certainly lessen the pain and suffering. Dr. Van Norman and Dr. Goldstein both testified that placing a central line involves accessing one of the larger veins, such as the carotid vein in the neck. They testified that a physician competent at the procedure would detect this vein with the use of an ultrasound. They testified that the experience a physician must have in order to be competent at setting a central line isn't just that they have had a medical education and been trained in doing it once. The key to competence in this procedure is that they use the skill on an ongoing basis. They maintain a sufficiently frequent practice of setting a central line that their skills do not lapse. Now, Dr. Van Norman gave us an example of what her hospital requires as competence, and that's a guideline. I'm not sure that everyone's going, certainly not every hospital probably has the same guidelines, but the bottom line, the central controlling factor is that the professional, the physician, have ongoing recent practice at the skill, just like so many skills that if we don't use it, we lose it. So that's the alternative on a central line. The other alternative that Ms. Pike has proposed, because the United States Supreme Court has required, in order for these suits to go forward, that there be a proposal of an alternative method of execution, is hanging. Now, this other alternative the testimony in this court demonstrates that it's a very old practice. It's something that death execution by hanging has been around for, I think, thousands of years. And certainly, it has been used fairly recently. It's certainly in my lifetime, at least. I know I'm one of the older ones here, but it's been used in Britain up until the 1960s, and more recently in the state of Washington in the 1990s. And of the two cases where someone was executed by judicial hanging in Washington, the testimony is that the state was able to achieve a transection of the spinal cord, in which case death was instantaneous. And that's comparing that to the strapping onto a gurney, searching for a suitable vein, inserting an IV, injecting with lethal injection, certainly would lessen the pain and suffering of the condemned inmate. And in cases where transection of the spinal cord doesn't occur, the evidence is that death by strangulation happens fairly quickly. In the one case in a medical review that was cited by Dr. Kelly, unconsciousness was achieved in 13 seconds. I believe her testimony was up to a minute for unconsciousness. This time frame is much less than the time frame involved in the lethal injection process. In addition, with hanging, there is no need to strap Ms. Pike to a gurney, no need to prod and find venous access, and no need for her to lie there reliving her sexual assaults by the involuntary actions of her traumatized brain. Hanging, which is not unconstitutional and has even been mentioned by the state as a constitutional form of hanging or of execution, is a readily available alternative that would significantly reduce a substantial risk of severe pain and torture. And in this case, that severe pain and torture, as testified to by Dr. Brand, is almost certain to happen. Your Honor, those are my arguments. Thank you.
Thank you very much.
May it please the court, Christa Pike has not shown a likelihood of success on the merits of any of her arguments for restraint. stay. And that is why we're here today. The Supreme Court referred 5 issues, now 4, to this court to help inform its determination on whether or not to grant a stay of execution so that Ms. Pike could pursue collateral litigation that may affect the method and timing of her execution. Now, to prevail, Ms. Pike has a double burden. First, she has to establish that execution under the current protocol, not just any protocol, not just lethal injection in general, or execution in general, presents a risk that is sure or very likely to cause serious illness and needless suffering and give rise to sufficiently imminent dangers. And that's language directly from Tennessee Supreme Court case of West versus Schofield. And it's quoting the United States Supreme Court case of Glossop versus Gross. And it's important to remember when thinking about this part of Ms. Pike's burden that speculation as to what could go wrong during an execution is not sufficient to meet that burden. Her job in this hearing was to produce scientific evidence that would allow this court to make this conclusion that there would be a substantial risk that is sure or very likely to cause needless suffering. But really, all she has done is present speculation about bad things that could happen. And we'll get into that issue by issue as we go through them. Second, she has to show a feasible and readily implemented alternative method of execution. And that method of execution also has to significantly reduce a substantial risk of severe pain. She also has to show that the state has refused to adopt that alternative without any legitimate penological reason. That's language from the Supreme Court case of Buckley that was discussed earlier. She's not done that either. These two burdens add up to what the Supreme Court, the United States Supreme Court, calls an exceedingly high bar to prevail on these kinds of method of execution challenges. And to date, no one, not a single person, has ever succeeded at either the Tennessee Supreme Court or the United States Supreme Court on what Ms. Pike is trying to do today. If she succeeds, she will be the first. Now, the standard under the Eighth Amendment, which governs these proceedings, is not a painless execution. That's well established. And the Eighth Amendment also does not require general anesthesia in a lethal injection execution. That's also well established. Pike has not come close to meeting her burden for any of these issues. We'll begin with the first, dealing with Ms. Pike's diagnosis of thrombocytosis and whether or not it's going to make peripheral IV access sure or very likely to cause serious illness and needless suffering. Now, several experts testified on this issue, but only one hematologist was called, and that was Dr. Mansour. Hematologists are the sort of doctors who have expertise managing thrombocytosis, diagnosing it, and taking care of patients. And Dr. Mansour testified that based on a review of Ms. Pike's medical records, he saw no indication that achieving peripheral IV access was going to pose any kind of problem. He testified that based on the medical records of her platelet counts, which he was very familiar with, there was no risk, or I should say there was a low risk of any kind of thrombotic event, including clotting at the IV site. He and Dr. Antonini also testified that they saw no risk of excessive bleeding at the IV site due to thrombocytosis. Now, opposing counsel attempted to play a little game of gotcha with Dr. Mansour, showing him some medical records of some platelet counts that he did not cite in his report. But not a single one of those platelet counts moved the needle. Not a single one of them showed, to his view, as a seasoned hematologist with 40 years of experience, that she is at high risk for any kind of adverse interaction with IV access. Plaintiff's experts, on the other hand, Ms. Pike's experts, cited no sources for their belief that her thrombocytosis was going to pose a risk of IV access issues. Again, Ms. Pike's burden was to produce scientific proof that she is sure or very likely to suffer severe pain as a result of this thrombocytosis. And she failed to establish that it carries anything beyond a minimal risk. The best she could do was to rely on the testimony of Dr. Van Norman, who was testifying outside her expertise as an anesthesiologist, and that with a failing track record in Tennessee execution litigation. She has simply not carried her burden here, and the court can rule today that she has failed to prevail on issue 1. Now as for issue 2, which deals with Ms. Pike's cited history of sexual assault and PTSD, the state does not dispute the terrible things that Ms. Pike suffered. I think everybody in this courtroom wishes that those things had never happened to Ms. Pike. I think we all wish that we were not here today and that she was not on death row. Certainly none of us take any pleasure in this. And so it's certainly not the state's intention to try to minimize the suffering that Ms. Pike has experienced. But that's not the issue before the court. The issue before the court is whether, as stated in the Supreme Court's order, is whether Ms. Pike's transport to Riverbend and observation by male guards would cause her serious suffering. Would be sure very likely to do that. Now, the evidence that came out on this point established that Ms. Pike will not be moved to Riverbend until 24 hours at the earliest before she is executed on September the 30th. The Department of Correctional witnesses also testified that they will make every effort to staff her observation at Riverbend with female guards. No evidence was introduced to contradict these facts. Ms. Pike's psychological expert testified at length about her opinions of what the effects of observation would be. And she testified that any close observation by male guards or by female guards would cause issues with Ms. Pike's mental health conditions. She also testified that extraction from her cell under any method of execution would cause mental health issues. The expert testified that the only way to eliminate these concerns effectively would be to execute Ms. Pike at Deborah Johnson Rehabilitation Center, immediately after extracting her from the cell where she's been housed for the past several years. But even that would require a cell extraction. That is undisputed. And officials from the Department of Correction testified as to why this is not feasible. Executions only happen at Riverbend. There are no facilities at Deborah Johnson to carry this out. So Ms. Pike's own experts' recommendations are impossible to carry out. The court must also consider, when examining this issue, that psychological harm alone is not sufficient to state an Eighth Amendment violation in this context. It's no doubt, no one disputes that every execution is distressing to the prisoner. But what Ms. Pike's expert failed to do is explain how any particular component of the execution gives rise to this enhanced risk of suffering as opposed to just the whole execution itself, which undoubtedly is distressing to anyone. This theory, issue 2, is essentially an attack on execution in general. It's not an attack on the Tennessee lethal injection protocol as it's written. It's not even an attack on lethal injection generally. Ms. Pike's position here appears to be that any execution protocol would violate her constitutional rights based on her mental health conditions. That is simply not the law. And the court also can find that she has failed to carry her burden on this issue as well. Moving to issue 3, which concerns Ms. Pike's allegedly small veins. Well, there is no proof that she has small veins. It was Ms. Pike's burden to show that. She didn't. There's no pictures, there's no video, None of her experts even visited her to examine her in person. So what the court is left with is a conclusory statement with no supporting evidence. Still, several experts examined her medical records and made their best conclusions about what those records showed. And what the testimony did show is that there are at least a dozen records of phlebotomy. 12 of those phlebotomy attempts were successful with one needle insertion, and one required 2 attempts. 12 of those phlebotomy reports stated that the skin site stopped bleeding as expected, and one report simply didn't answer that question. An anesthesiologist, a hematologist, and a nurse vascular expert all testified that they had reviewed Ms. Pike's medical records and saw nothing indicating that there would be a problem achieving peripheral IV access. Those medical records contain no indication of a failed IV attempt, no indication of any other trouble with needles. So what's left is mere speculation about what could go wrong. And as the Tennessee Supreme Court just explained last week in the Hines case, that is insufficient as a matter of law to state a claim for an Eighth Amendment violation. Ms. Pike cannot show a likelihood of success on this. Now, she attempted to cast doubt on the qualifications of the IV team to place IV access. But what came in fact, was that members of this IV team are all currently certified to place IVs in the state of Tennessee. That was verified very recently by Assistant Commissioner Thomas. She personally verified that each member of the IV team has decades of experience placing IVs. And that is the single most important criteria cited by one of plaintiff's experts as to whether or not someone is going to be able to achieve IV access. More than that, there were no studies cited indicating that small veins is even a recognized medical term. And there's no evidence that repeated IV attempts, even if they're necessary, would constitute anything more than the average discomfort tens of thousands of people experience every day in clinics and hospitals across this country. This utter failure to adduce any evidence to show anything more than a possibility of pain due to peripheral IV access dooms this claim. Lastly, issue 4. And this is a particularly significant issue because, as I stated at the beginning, Ms. Pike's burden under the law is to also establish a feasible and readily available alternative method of execution. If she cannot do that, she cannot succeed on any claim before this court or before the Supreme Court. And Ms. Pike failed rather spectacularly to carry her burden at this point. She abandoned the 23-gauge butterfly needle wisely after her own expert in their reports declared that it would require a tremendous amount of pressure to push the amount of fluid through it that would be required, and that it could result in complications. Her own experts also foreclosed any idea of a central line alone as a method because they testified that it's relatively dangerous, in Dr. Van Noren's words. And Dr. Goldstein testified that the risk of complications is significant, and that the nature of those complications is severe, including organ damage and life-threatening arterial bleeding. There's no testimony that these kinds of complications would arise from peripheral IV access. And that leaves hanging is the only possible alternative that Ms. Pike could prevail on. If she couldn't achieve that in this hearing, all of her claims are out the door. And yet her only expert on this topic was utterly unqualified and unprepared. He based his expertise on a report that stated, in bold letters in a disclaimer, that AI had been used to write it. or actually, that was an article that he had authored. He could cite no source for his conclusion that hanging causes loss of consciousness in the 20 to 30 second range. The court gave him multiple opportunities, several minutes to peruse the documents he reviewed. He came up with nothing. All he did was write a book report, and a failing one at that. Now, what the experts did agree on is that hanging is an unpredictable way of causing death. In other words, when someone is tied to a rope and they're dropped, no one quite knows how they're going to die. Their head could be taken off, their spinal cord could be snapped, their arteries could be cut inside their neck, or they could just hang there, strangling to death. Now, both experts testified that if it's done right, hanging can be instant. But it's not always done right. And it's not easy to do right. And there's been no evidence presented that Tennessee could do it right. There's no evidence presented that Tennessee has the expertise and the materials to carry out hanging as a method of execution. Now, the only time frame cited in support of this method of hanging to cause unconsciousness, I believe it was 13 seconds. But that was based on only one case involving one individual who happened to videotape his own hanging. And that was based on an apparent loss of consciousness, as stated in the literature. That is insufficient grounds for the court to conclude that hanging offers a substantially less painful alternative to lethal injection. And this, of course, is even assuming that the first two methods that Pike proposed even qualify as methods of execution. It was stated earlier that the spirit of the United States Supreme Court's jurisprudence on this contemplates a central line or an equipment swap or something of that nature as an alternative method. Well, the U.S. Supreme Court doesn't speak through a spirit, it speaks through its holdings. And nothing in its holdings has ever said that an alternative method of execution is anything other than a distinct way to cause death. Now, hanging is one, but as I previously said, Ms. Pike has not carried her burden to show that hanging is a viable alternative. Now, of course, this issue hinges on a comparison, as the court previously observed. The alternative has to be compared to the existing protocol. And what the evidence showed about the existing protocol, lethal injection by pentobarbital, is that it produces unconsciousness within 20 to 30 seconds. Dr. Antonini's opinion on this topic was supported by scientific evidence, which he was able to defend in cross-examination. Unlike some of the other experts, he had actually read the reports he cited and could explain them, and could explain how they related to his conclusions. He also testified that after that 20 to 30 second time frame, the inmate will be incapable of feeling pain. And plaintiff's experts had no reliable scientific evidence of their own to rebut this conclusion. Dr. Zivit repeatedly ducked the court's questions about how long it would take for an inmate to lose consciousness under a dose of 5 grams of pentobarbital. He had apparently learned nothing since the case of Buckley, where it was noted that he engaged in a similar pattern of evasiveness when pressed on that question. He just couldn't offer a conclusion to the court on the point. And so the court is left with nothing but Dr. Antonini's opinion on this topic. In addition, there is no evidence that there is any variability in how pentobarbital causes death. Dr. Antonini testified that within seconds after it's administered, it leads to cardiovascular collapse and an essential brain death, or EEG silence, as he stated. In the brief time before that happens, the inmate would not feel pain. He did testify that in some cases, there could be mild discomfort from the actual injection of the drug, but that would be no different from the experience of having that drug injected in a clinical setting. Ms. Pike repeatedly attempted to point to risks of IV failure, such as what would happen if pentobarbital were injected into surrounding tissue, extravasation. But she introduced no evidence that this is sure or very likely to happen. All experts agree this is a possibility. It's a possibility with any kind of injected drug. But specific to this case and this protocol, there has been no evidence to show that that is a likely outcome. Again, all we have is speculation, which is insufficient to carry the burden. Dr. Antonini also testified extensively about the issue of pulmonary edema. He offered studies and detailed defenses of those studies to explain how pulmonary edema can develop after death. I think it's fair to say that the experts agree that it's ultimately not 100% knowable how much pulmonary edema might occur before death and how much might occur after. They both concede that some might happen before and some might happen after. But there is certainly no evidence to show that it is sure or very likely that pulmonary edema is a side effect of the dose of pentobarbital that's administered under Tennessee's protocol. There's also been no evidence to show that it's sure or very likely that Ms. Pike's thrombocytosis will lead to pulmonary edema or that it would cause more severe pulmonary edema. Again, it was Ms. Pike's burden to come forth with scientific evidence to show that these issues are sure or very likely to happen. And she has completely failed to do that. And so in light of these failures, the court should find that Ms. Pike cannot prevail on any of the issues referred to by the Supreme Court. And the court can make that ruling today. Thank you.
I had not anticipated this being an argument like a rebuttal, but if you want, I'll let you.
There's one thing that I want to clarify for the court that I think is pertinent to these proceedings. And that is when opposing counsel got up and immediately started talking about the standard for a stay. And I understand that that's what our motion has been construed as in the Tennessee Supreme Court. When we began challenging what was going on with our suit in Chancery Court before we went to the Tennessee Supreme Court, we were never looking for a stay. The introduction of the amendment to Rule 12 now seems to require that you ask for a stay. From the very beginning, we were looking for a humane way to carry this out and to minimize the time that would be involved in the actual execution. And I think that that has been Ms. Pike's goal all along. And the fact that she has experienced difficult venous access that has been verified by our experts in their testimony of what they think the causes are, led her to be afraid that what might happen would be stick after stick after stick that's unsuccessful, followed by maybe a central line. So we began trying to find solutions within the lethal injection process that could make this a short and less traumatic experience. And that has been our goal all along. And the alternatives we've proposed here, especially after consulting with our experts about the butterfly needle and all that, is that a central line would be the quickest, least traumatic experience that she would have. Followed by, when we began looking into it, hanging. And certainly the expert that the state presented talked about the fact that it was transection of the neck, of the spinal cord, and instantaneous death, and would not involve the trauma of lying on a gurney surrounded by people, possibly men, possibly all men, maybe not, we don't know. But we have been seeking that. And the only way to do that, evidently under Rule 12, is to ask for a stay. And that's why we're here, and that's why we're under that standard. But I agree with Your Honor that the question is a comparison. And I think that even though the state says psychological problems are not necessarily or have not necessarily been recognized by the United States Supreme Court, the state will not deny that they're very real. And in this case, they're very real, and the torturous aspect is not only very real, but sure or very likely to cause tremendous and excruciating psychological distress at the moment of death. And if this has to happen, which we certainly don't want at all, obviously we represent Ms. Pike and we don't want her to be executed. But if she is executed, it has always been her goal and our goal to avoid that trauma. And therefore we ask that this court recognize that and the psychological trauma that would take place and find for one of our alternatives, either the central line that makes it a lot quicker and the complications, the dangerous aspects of it is this isn't a medical procedure to save her life. There certainly are some dangerous aspects, but the reality is that the pentobarbital would get where it needs to go and cause death in a much faster, less torturous way. And then since, in order to present a case to the Tennessee Supreme Court, we had to identify another alternative. Our exploration of hanging seemed to address all of those needs of it being quick, instantaneous possibly, and at worst, still probably shorter than lethal injection. Those reasons we ask that you find those facts necessary for the Tennessee Supreme Court to grant us relief. Thank you, Your Honor.
I have a few observations because both of you mentioned things that are probably beyond the scope of my duties and responsibilities here. I've got 4 questions now that I have to answer, and that's what I'm going to do. But after I answer those 4 questions, both sides are going to be arguing much of what he just talked about with the Tennessee Supreme Court. And the issue in the Tennessee Supreme Court is going to be whether or not they grant you a stay of execution so that you can pursue your collateral litigation. In the Tennessee Supreme Court, you've got to show a likelihood of success in your collateral litigation, or they're not going to give you a stay. And so that's going to be the standard in the Tennessee Supreme Court. Question I'll pose, they have to decide the likelihood of your success in your collateral litigation, but not file a complaint in the Tennessee Supreme Court that tells them what your collateral litigation is. Apparently, they're going to have to make that decision from a hypothetical complaint that might exist somewhere out there in the world of imagination. Every court I've ever known, that if you were filing a request for a stay based upon your desire to pursue collateral litigation, you would have to file a copy of the complaint so the Supreme Court could analyze whether you have a likelihood of success. Not for me to decide, but I'm mentioning this to the lawyers because that's probably going to be something that would need to be discussed in the lawyers. Understanding that this protocol went into effect in January of 2025, and you waited a year to file litigation to challenge it. You weren't death sentence set 9 months later. And so unless you completed your collateral litigation in 9 months, you were going to eventually have to ask the Supreme Court for a stay. And even before Rule 12 was in existence, the standard required you to show the likelihood of success. So anyway, these are just issues that they're beyond the realm of this court's masters. Never been called a special master, it probably never will be again. But anyway, is that everything that everyone wants to say? And we're adjourned, and we will wish everyone, including Ms. Pike, the best of luck in the future with anything that you pursue. And I want to thank the lawyers for their professionalism. You seem to work well together and very cordially and amicably. And it's been a pleasure to get to meet all of you and to work with you. We know the time schedule, the crunch is upon us. Appreciate y'all working under this time pressure. And I will have finding of fact and conclusions of law on these narrow issues. Now, both of you argue things beyond the scope of these questions. Because that will be subject to your briefing in the Tennessee Supreme Court. I won't necessarily be answering anything that's beyond the scope of these questions. I'll limit it to the questions. And I believe that the answers to these questions are all that the Supreme Court needs to make the determination. I think they hinted in their order that if they needed more, that I'd hear from them. So I don't know what to expect on that, but you'll have my findings and back and conclusions of all next Friday, the 21st of August. We're adjourned.